Are you trying to unravel the secrets locked in Georgia's divorce records, but honestly just don't know where to start? Well, stay tuned because today we're going to discover the step-by-step process to access them online for free and effortlessly. Welcome to this explainer, where we're going to act as your personal digital detectives. Today, we are completely decoding the sometimes confusing, highly decentralized, yet totally accessible world of Georgia divorce records.
Now, you might be sitting there wondering, why on earth are these highly sensitive records even available to the public in the first place? Well, it all comes down to the Georgia Open Records Act of 1959, which basically states that court proceedings, and yes, that includes divorces, are legally considered public domain. And honestly, this is incredibly useful information. Whether you're a genealogist trying to piece together a really complex family tree, a journalist looking into public figures, or maybe just an individual who needs to verify your own legal status for a new marriage or property transaction, these public records are absolutely your starting point.
Okay, let's dive right into this. Here is our roadmap for today. First up, secrets in the public record. Second, navigating the two eras. Third, our step-by-step online search. Fourth, overcoming county access hurdles. And finally, number 5, privacy, ethics, and sealing.
Starting off with Section 1, Secrets in the Public Record.
So, when a judge finalizes a divorce down in Georgia, that case file actually transitions straight into the public domain, and the sheer amount of personal data that suddenly becomes accessible might totally shock you. We are talking about highly sensitive biographical and structural data, things like the full names of both spouses, the specific asserted grounds for the divorce, the exact child custody and visitation arrangements, right down to who gets the house and the property and debt division matrices, and the specific terms of spousal or child support. It's the whole shebang. Now, while all these basic financial and custody agreements are completely public, it is worth noting that things like psychological evaluations or private medical information are usually excluded unless they're specifically submitted as evidence in a contested trial.
Now, before we get too deep, there is a major stumbling block that trips up a lot of researchers here. You really have to know exactly what you're looking for. There is a massive difference between a divorce verification and a divorce decree. A verification is simply a certified letter from the State Office of Vital Records confirming that, yes, a divorce happened, and it lists the date and the county, but it doesn't give you any of the juicy details. The divorce decree, on the other hand, is the actual detailed legal document outlining the entire settlement, and that decree is held exclusively by the clerk of Superior Court in the specific county where the divorce was filed. Moving right along to Section 2, Navigating the Two Eras. All right, here's the major plot twist of Georgia's record system. There's a structural bifurcation, and it depends entirely on the year the divorce was finalized. Think about the historical registry era, which runs from June 1952 to August 1996. If your target divorce happened during that window, the State Office of Vital Records can issue that verification letter for a $10 fee. But notice the primary custodians for the archival era, which is before 1952, and the modern era, which is anything post-1996. For those specific dates, the state office has absolutely zero record of the event. You have to go directly to the county clerk of Superior Court. And remember, even for that middle era, the state only has the verification. The county always holds the actual decree. Which brings us to Section 3, Step-by-Step Online Search. So how do we actually get our hands on these documents using free state and county portals? Well, if you're hunting for historical records between 1965 and 1998, you are in luck. You're going to use the Georgia Government Publications, or GGP, portal. Here's the exact sequence you need to follow. First, go to the GGP website. Second, in the search filter dropdown, set it to author and type this exact, highly specific agency name: Georgia.Dept of Human Resources, Division of Public Health, Vital Records Service. Third, sort your results by title so you can group them chronologically. Fourth, use the advanced search to add the keyword divorce. Once you find the name you're looking for in these digitized microfiche indexes, you're going to see a 3-digit county code. You'll just need to cross-reference that with an alphabetical state coding table to find out exactly which county to contact for the physical decree. But what if you're looking for a modern divorce, something filed after 1996? The workflow totally changes here. First, you'll want to register for a free basic account on a platform called ResearchGA. This is a massive time saver because it actually lets you search party names across 25 integrated counties simultaneously. If you don't find them there, you can check local clerk portals, which are often hosted by Peach Court, where you can search civil dockets completely for free. Now, finding and viewing the index is free, but if you need an official, tamper-proofed, certified copy of the decree for legal reasons, you'll use the GSCCA e-certification portal. That usually incurs a small fee, like DeKalb County's $5 charge per copy, for example. Let's pivot to Section 4, Overcoming county access hurdles. Because Georgia delegates all this administrative authority to its 159 individual counties, your research experience is going to vary wildly depending on exactly where the divorce was filed. Let's compare Cobb County and Fulton County. Cobb County represents basically the most open access model in the state. Literally from your couch, you can go to their web portal, search a name, and view and print most divorce documents entirely for free. Now look at Fulton County. They use a highly restrictive model. On their website, you can only see the metadata, meaning just the case number and the titles of the documents filed. If you actually want to read what those documents say, you have no choice but to get in your car and physically visit the courthouse in Atlanta. But wait, what if you've done all the searches and you simply cannot figure out which county the divorce was filed in? Here's a lesser-known, kind of expert workaround. You can register for a free limited-use account with the GSCCCA. That's the Georgia Superior Court Clerks Cooperative Authority. From there, you can search the statewide Civil Case Index. Now, it won't give you the actual documents, but it will tell you exactly which county holds the docket, pointing you right to the correct courthouse.
Finally, we reach Section 5, Privacy, Ethics, and Sealing.
Now that you know exactly how to find this information, it usually sparks a massive privacy concern for most people. The Stearns Law blog really hits the nail on the head here, stating, "The internet has made it easy for virtually anyone to find out your private details." They use the anecdote of the stars from the TV show Flip or Flop. When their marriage ended, everyone wanted the details. But public interest in divorces isn't just a celebrity problem. It can be a genuine shock to realize that an inquisitive neighbor, a prospective employer, or even a new romantic partner could theoretically log onto a county portal and read your personal child custody arrangements or how you divided your debt. So how do you actually protect yourself in an open record state like Georgia? Well, there are three main strategies you can use. First, resolve your disputes via private mediation. If you hash out all the arguments in mediation, only the finalized settlement agreement gets filed with the court, which keeps all the messy negotiations totally off the public record. Second, you can redact sensitive data, like listing only the birth years of your children to help prevent identity theft. Third, you can file a formal motion to seal the records. But be warned, this requires a judge's approval. A judge actually must find a compelling reason where the harm to your privacy legally outweighs the public's right to transparency. And honestly, this is usually only granted to protect the welfare of minors or proprietary business trade secrets. Which brings us to a really important note. The information provided in this explainer is just meant to give you a general blueprint and guidance on how these systems operate. However, if you are dealing with a divorce, privacy concerns, or you need official documents for real legal proceedings, always verify your findings with the official state and county clerks, and please consult a qualified legal professional for your specific situation. Well, we have absolutely covered a lot of ground today, navigating everywhere from historical microfiche indexes right up to modern digital portals. But before we wrap up, I want to leave you with a final provocative thought. As we balance the Georgia Open Records Act with the highly sensitive nature of family law, we really have to ask ourselves, transparency or privacy? Where do we draw the line on public access to private pain? Is the state's presumption of open courts worth the potential exposure of our most vulnerable moments? Think about that for a second, and let us know your experiences navigating these records in the comments below. Thanks so much for joining me on this explainer, and keep exploring.